Hi everyone, I'm Hanovi Schoonover, the Training and Resource Coordinator for Redwing Consulting, and I'd like to welcome you to the webinar. Before we begin, for those who may not know, Redwind is a nonprofit organization that provides tribal technical assistance on a variety of programs, including but not limited to housing and homeless services, children and youth, and elder abuse. This ranges from policy review via email to site visits. If you're interested, you can contact me at hanovi@red-wind.net. That's HONOVI at red-wind.net. This presentation is not necessarily representative of the views and policies of the DOJ or OVW. All the opinions and recommendations within are those of the author. Presenting with us today is Alicia Aiken. Alicia is a principal at the Danu Center for Strategic Advocacy and the director of the Danu Center's Confidentiality Institute, a national policy and technical assistance project that supports helping professionals to protect privacy for crime victims. She is also the faculty fellow for Practicing Law Institute's Interactive Learning Center, where she designs innovative programs that teach lawyers to work well with individual clients. She has dedicated 25 years to working within the public and nonprofit sectors to further social justice for people living in poverty and surviving violence. And she has a deep understanding of the legal and social services nonprofit sector, as she has been spending 15 years as a trial attorney and then a member of the executive committee at Legal Aid Chicago. Before we begin, if you have any questions, you can put them into the chat or raise your hand, and at an opportune time, we will answer those. And I will now turn it over to Alicia.
Thank you so much. Thanks to the folks who are here. We're asking everybody to just introduce yourself in the chat, just so we have a sense of who's here with us today. And I'd really like to find ways for this to be interactive, for us to be able to talk with each other, because all of these issues around confidentiality and survivor-centered services and focusing on the needs of the urban Native community and all the ways in which people end up getting spread out between different organizations to get their needs met. These are complicated things, and there's not a one-size-fits-all answer. And so talking it through and discussing our experiences and sharing strategies with each other is a real key to finding best practices and to developing our skills. So it's incredibly important that this not just be me talking at you, but it be all of us sharing with each other. So to that end, you can use the chat. I'm going to keep an eye on the chat box as it's going. If you have a question, you can ask it when you have it. I will make a judgment call about whether, if it's something I know I'm going to answer a little later in the presentation, I may wait, or I may hold it until the end, or if it's spot on and it's something we should address right now, I will address it right now. Or if you would rather speak a question, you can also either raise your hand or just put something in the chat, and then I'll recognize you and you can unmute yourself. If you can keep yourself on mute when you're not talking, then that helps us eliminate background noise. But if you're not talking to me and we're not sharing, then it's just year two of me alone in an office staring at a wall. I would prefer not to feel that way. I prefer to feel like I'm in a room with you if it's possible. So the closest we can get to that. Our goals for today, the conversation, is to walk away with a good firm understanding of what we really mean by privacy, confidentiality, and privilege, how those terms are different, how they're connected, and how they impact your work. To consider how confidentiality and different approaches to it impacts collaboration across agencies, and then to have a really robust conversation about what a person-centered approach to releases might look like. And some folks call them ROIs or waivers or consent forms, But essentially what I'm talking about is how do we have an approach to getting written instructions from survivors about what they want us to do with their information? How do we make that really a reflection of their will? So in case you forget later on, we're going to make sure you get a handout of the presentation, and that'll give you a super brief background on me. I also want to make sure you have the website for my organization. So the Confidentiality Institute is that focused in on specifically the issue of privacy for violence survivors and crime victims. But it's also a project of a larger organization called the Danu Center for Strategic Advocacy. And the goal of the Danu Center is to help mission-based organizations and communities achieve the vision that they have of the world. So whether that is how do we run our organization internally in a way that's consistent with what we believe about the world, or how do we communicate with the outside world about collaboration and partnership, or how do we achieve advocacy goals in the community so that we're building the place that we want to be. So let's start with that fundamental of confidentiality principles. But we're actually going to start with a question that I have for you. So I'm gonna make an assertion that privacy, safety, and trauma are all linked. And I'd like your thoughts. So use the chat, or if you'd rather speak, you can raise your hand and I'll recognize you. What do you think I mean by that? What does it mean to you when I say privacy, safety, and trauma are linked? And I will wait. I'm happy to wait to give you some time to think about it, but I really want to hear from you. Okay, let's try a different question then. If this one's not landing for you, let's take a step back and try a different question. We often talk in the victim services community about safety, about the importance of safety, about the struggle to find safety. What do we mean by safety? What, when we're thinking of either about your own life or about your work with violence survivors, what do we mean by safety? What's that about? What does safety look like? What does it feel like? What's a concrete example of it? Ava, do you have thoughts? I know you introduced yourself in the beginning, so I'm going to put you on the hot seat a little bit. Do you have thoughts about either question? What do we mean by safety? Or what are the ways in which privacy, safety, and trauma are linked? And anyone else is allowed to weigh in here and save Ava from me calling them out.
I wonder if she, oh, never mind.
Yep, there we go. I'm trying to learn to be patient. Patience was not a thing I got taught in my childhood, but I'm working on it because people need time to think, right? So safety and privacy can go hand in hand, and the lack of them can cause trauma. And it's a really nice, concise statement, right, of the connection. Like what is, and they are big concepts. You're absolutely right. There's nothing to apologize for. So a lot of times when I ask people this question in training, the first thing we go to when we say, well, what is safety? A lot of the answers I get are not being physically assaulted, right? That's a super obvious example of safety. And it's an important one, but sometimes that one can get too much priority. Not too much priority is not the right way to put it. That when we, as workers, focus on we have to do things to prevent someone getting physically assaulted, sometimes that can lead us to lose track of other important elements of what it means to feel safe as we move through the world, right? And so I think Ava, and just so you know, Ava, I have 3 folks on the attendee list listed as Angel Rate, including you. So I don't know if the other 2 are different folks, also under the same name. But I think this is you additionally weighing in that trauma can increase people's need for privacy and safety, and that privacy is a way to make people feel safer. Exactly. So the point I want us to remember is that feeling safe is a subjective feeling, that it is not an external, I have decided that you are safe right now because of where you're living, or because of who you're living with, or because of which services you've been given, or because of what court assistance you've been given. That equals you are safe and you feel safe. That's not how it works. Safety is a very subjective thing. What circumstances and spaces feel safe or unsafe are different. Right? Whether you feel safe or safer walking into an organization that specializes in focusing on the needs of the Native community, and especially folks who are navigating living in a city and feeling like people forget that you're there. Maybe you feel safer walking into an organization that focuses on meeting those kinds of needs. Maybe you feel safer walking into an organization that is entirely disconnected from your community because you don't want to worry about people talking or sharing information, right? And that calculation is going to be different for different people. And so it's an incredibly important thing to be aware of, that when people are coming in to get help, to get services, they're going to have in their head a calculus of what they need and what they want. They won't always feel like they're allowed to say it out loud. Sometimes they won't even be fully aware of the calculus. They're just going to be clocking a situation and trying to make judgment calls about what feels okay. And some people feel entirely safe. It makes them feel safer to have a lot of professionals talking about what they need. For some people, that is the best possible outcome. I have a team, and my team is fully informed, and my team knows everything about me. And so that means there are more people trying to help me get what I need. That feels safer and better to me. The way that trauma links into that is that especially if you're working with people who have experienced violence within their families, within their intimate relationships, or frankly, actually, and then I'm going to say the opposite, where if you've experienced violence by a stranger that came out of the blue, all of those things are violations of the social contract. All of them can make you feel totally disoriented and unmoored, and it can make it harder to build trust and feel safe in new situations going forward, right? Because in the past situation, you may have thought that wherever you were was a safe space, and then you were violated and it wasn't. And so now you might doubt your own ability to judge safe spaces. And so that makes it more complicated for you. And so more control, more choice, more privacy can create spaces where you feel more okay. And so thank you. So to the 3 angels who are coming in, I don't know why you're coming in as the same name, but maybe you could, when you do weigh in on the chat, if you can just use your name at the beginning of your comment, and then I'll know when different people are communicating. The machines do things, we don't always know why, we just move forward, right? The story that I often tell people to help them sort of connect to the way that safety is different for different people in different places is that, the truth is that for me personally, I grew up almost exclusively living in either cities or suburbs of cities, but very much spaces where I was taught as a young woman that in order to feel safe when I was moving around in spaces, I wanted there to be a lot of lighting and I wanted there to be a lot of people. That's a very specific sort of message about how you want to move in the world and what are safe spaces. I moved to rural Vermont. And when I moved to rural Vermont, there's not a lot of light, which is great because you can see the Milky Way at night and it's beautiful. And there's not a lot of people. It's not a heavily populated area. There are very few cities. And on paper, it is a safer place than living in Chicago. But in reality, I felt very nervous being outside at night, either by myself or with someone else. I always felt a little bit itchy and uncomfortable. And when I moved away from Vermont and back to Chicago, I felt much calmer. I felt more centered. I felt more stable. Now, again, an outsider might have said, on paper, your physical person is safer statistically in Vermont than it is in Chicago, but it wasn't working for me. And so we want to remember that when we're doing services with people, that whenever somebody walks in the door, they're not going to have the same calculus that we have. And so we don't get to decide for them. I emphasize this. I spend a lot of time emphasizing this because I see a pattern where people think a lot of workers, service providers, and I come from a direct services legal aid background, so I'm in this category too, tend to develop a belief that I know how to judge for someone else who it is safe to share information with. It's a good guy, bad guy construct. And I want us to step away from that idea and think, who's in charge? Who's driving the bus? Who's getting to make the decisions? That's the real calculus that we want to be paying attention to, not who do I think is a good guy or a bad guy or trustworthy or untrustworthy, but who does the survivor feel is trustworthy or safe for them. All right. So keeping that kind of philosophy in mind, I want us to think for a moment about the differences between privacy and confidentiality and privilege. Privacy is that issue of I decide who knows what about me. I choose who knows my information. I might choose to share. I might choose to withhold. I might choose to tell someone else, don't share. Those are all privacy choices. Privacy isn't keeping secrets. Privacy is making choices. Think of it as choices. Confidentiality is something that applies to professionals. So a domestic violence advocate, a sexual assault crisis line, a lawyer, a doctor, a therapist. These are all professions where you likely will be saying to someone, I am here and you can share with me and I will give you control over how else your information gets shared. You get to make the decisions whether I tell anyone else. And there's always some exceptions to everyone's confidentiality. There's always some spaces where there's a rule that you must share information. And so we tell people that, right? We say, these are my promises that I'm making to you about how I will protect your information. And I'm giving you an upfront notice that there are a couple places where you won't be able to make the decision because the law says, for instance, it's very common that folks are mandatory reporters of child abuse. You are protecting someone's privacy when you tell them up front that you have that kind of rule, because then they're going to make choices about whether and how to share with you. Privilege is it is related to confidentiality. We often say that privilege applies to confidential communications, but privilege is really a rule against judges. It's a rule against police officers, and it's a rule against prosecutors and lawyers. And it says, if there's information that you want, that is interesting and useful to the court case or what you're doing. If it is privileged information, then that means the people who hold it have a privilege to tell you no. Privilege means they cannot force you to share information. Sometimes the way I think about it is privacy is a choice about how to share information. Confidentiality is a promise that the worker won't volunteer information, that the worker will respect choice. And privilege is a rule that says you can't make me, you have to respect my choice. So keeping those things separate, because especially as you're starting to think about working with different professions or across different professions, different folks are going to have a different set of rules and approaches to the confidentiality promise. They're going to have different exceptions to it. And different folks are going to have different abilities to protect information in court under privilege. And the determination about what are your exceptions to confidentiality or how do you manage information really have an awful lot to do about what is the work that you're doing? What kind of work are you doing? Is it the kind of work where your role is to promote autonomy? And the other way to think about autonomy is that you're really supporting someone else's decision making, right? Autonomy is, I have a 20-year-old son right now, and it was very interesting when he left for college. It was a moment where I was like, oh, so my parenting role now is to support him to make his decisions, to be a sounding board for him, to educate him about the world. But it is no longer my job to actively protect him from harm or to tell him what to do, because now I'm in a different role where my goal, my parenting goal, is to promote his autonomy and to support his decision making. Obviously, parenting is a different thing from a work environment, but I offer it as an example to think about what's your role. So for victim service providers, to a large extent, that role is supporting autonomy. But in other professions, your job is to prevent harm, right? So that's law enforcement. Much of what the law enforcement's on-paper job, and we know that in our country, it doesn't always play out that way, but the on-paper job of law enforcement is often to prevent harm or to interrupt harm. And if you think about like what sort of other professions might be doing, they're trying to save someone from ongoing harm. And that's called beneficence. So those folks might be making more decisions about sharing information. If the goal of your work is to prevent harm, then you're going to be coming from a position of what do I need to do to prevent harm? But if the goal of your work is to promote autonomy, then often you're not going to be making decisions about what happens next or how to share information next, because you're really trying to support someone to make their own choices about that. So as I said before, I think one of the important things to remember about victim advocacy work, if you're a Violence Against Women Act funded victim services provider, the core ethical principle of that work is to promote autonomy. And what that means is that the survivor is making the decision about what happens next. They're making the decision about what information gets shared. They are making the decision about what kind of help they want to seek. They are making the decision about what strategies assist them and what strategies do not, which professionals they want to engage with and which ones they do not. I think this is a tricky concept for some other professions like law enforcement, like doctors, to wrap their head around, because I would say that victim advocacy is the area of work where this idea that the person you are serving is making all the decisions, this is a place where it is the strictest, the most consistent. I think if you're doing medical care, part of what you're doing is promoting patient autonomy, and part of what you're doing is being an expert who prevents harm. and it's a mix of those two things. But if you're doing victim advocacy, it's not a mix. It is you are supporting, you're lifting up the voice of someone else. You are supporting them to find their voice and to use their voice. And where they don't want to use it, you don't decide to use yours on their behalf. I know some folks have come in and may have missed kind of my opening plea to you to use the chat to send in your questions whenever you have them. I'm going to keep an eye on the chat as I'm presenting. My goal is to be as interactive as possible, and to learn from you and have you learn from each other just as much as I'm sharing things with you. So please use the chat, or if there's a question you want to ask or a comment you want to make and you would rather speak it, just raise your hand or send in a chat that says, you know, I'd like a chance to speak, and then I'll recognize you and you can unmute yourself. So sort of talking a little bit more about that difference between the medical profession, healthcare, and victim services, I want to talk about the two different confidentiality rules. And this is a very quick coverage of this topic. If you have more questions, I'm going to tell you where you can get more resources about it. But there is a lot of times a perception in the United States that HIPAA is the best privacy rule. And that's not true. HIPAA is a privacy rule for a specific purpose and a specific profession. And the Violence Against Women Act, Victim of Crime Act, and Family Violence Prevention and Services Act, those are those three acronyms up there, VAWA, VOCA, and FIPSA. They have a different confidentiality rule. And it's not that that's the best privacy rule either. It is a specific rule for a specific profession. So I want to take just a minute to distinguish between them, because if you're doing collaboration in your community, or if survivors might be moving between different kinds of organizations, they're going to be encountering different confidentiality rules, and it's important to be aware of how they're different. So under the HIPAA privacy rule, there is a lot of discretion and power for the healthcare professional to make choices about sharing information. And the idea is that healthcare professionals are experts in an area that the patients are not experts in. And that when more healthcare professionals are talking to each other, then they can access more expertise, and then they can make both better decisions, but also give better medical advice and medical care. So in a very short version of the HIPAA privacy rule is that it allows professionals, without ever checking in with the patient, to share whatever information they decide is a good idea for anything related to providing healthcare. And there's actually kind of a lot of discretion in deciding, I think this is related to providing healthcare, I think this is necessary. The United States has also made a choice to make its healthcare system part of its capitalist business enterprise system. And so people want to get paid for providing healthcare. So they are allowed to do a fair amount of sharing information about their patients in order to manage the business of healthcare, in order to get paid, in order to communicate with insurance companies, so that they get paid. I mean, we've put our healthcare system into the capitalist model, and the capitalist model says that people have to get paid in return for providing services. And so HIPAA says you don't have to check in with the patient. If it's part of managing the business, you can share it in order to make sure that you get paid. I want to emphasize what I'm saying is that HIPAA gives, as long as it's related to providing healthcare, HIPAA gives the power to decide to share to the healthcare professionals, and they don't have to check in with the patient first. But it doesn't mean they have to share. It just means they can make the choice. It is possible that there can be a local statute or a court order, a valid court order that can force sharing. And that means it's not the healthcare professional deciding and it's not the patient deciding, it is the law deciding. It is a judge or a legislature deciding this information has to be shared. And then patients can always say, I want you to share my information. So for instance, if a patient wanted their healthcare professional to share information with the police because it would help them participate in a prosecution, a patient can always request that. But to make that kind of sharing, the doctor would not be able to make that choice because because that's not related to providing healthcare, but the patient can make that choice. Can folks do me a favor? Give me a thumbs up if this is making sense, because this is tricky. People spend years studying HIPAA and trying to make sense of it. So you can give me a yes in the chat box. I'm getting it. It makes sense. You can give me a thumbs up. You can give me whatever other reactions they have, or you can ask a question. Fantastic. Thank you, Simone and Laura. Okay. So if that's what HIPAA, what the healthcare professional confidentiality rule is, then what is the difference under VAWA, VOCA, and FIPSA? And again, the attempt there is to have the same rule because all three of these are grant streams that fund victim services work. So that rule is that the violence survivor, the person who came in for help, gets to choose whether and when to share their own information. They get to choose whether and when to share their own information. And the advocates, the victim service providers, do not get to make that choice. You don't have discretion to say, I think this is a good idea. I think I'm more of an expert in this situation than the violence survivor. And so I think sharing this information helps. I get to decide to do it. Only the violence survivor gets to make that choice. This, by the way, this distinction between HIPAA and VAWA can cause a lot of conflict between healthcare professionals and victim services professionals, or it can cause conflict if you're talking to a law enforcement professional who's used to talking to healthcare and now they're talking to victim services. Like just this difference in people's lack of awareness about this difference can be the source of a lot of conflict. So when we do the work to really understand each other across different professions, then I think that relationships get stronger. Then sometimes you can say, hey, I know that the way I'm doing this is different than the way that you do it. And that's okay. It doesn't mean one of us is right and one of us is wrong. It just means we're different. And when we understand those differences and where they come from and why they exist, then we can work together better. Now, advocates, victim service providers are allowed to share information inside of their own agency, and that's inside of their own victim services unit. So essentially what the federal funding streams ask you to do if you are providing, if you're getting funding and you're providing victim services, they say, figure out who inside of your organization is providing victim services. All of those people in that unit need to follow the same strict VAWA, VOCA, FIPSA privacy rule. And as needed to do that work, you can share information. Because we don't think it's a good idea to have only one person talking to one survivor, and then that one person is carrying the weight of everything that survivor is sharing or asking for or needing. One person shouldn't have to carry that, especially if one person is working with 20 or 30 survivors, and then you're carrying the weight of all those people. Like, it is better to have a team, but it needs to be a team of people who are all following the same rules. The same strict survivor decides rule about information. So sometimes that can pose complexity for multidisciplinary organizations that do a lot of different things and now are taking some federal money to do victim services. If that applies to you or your organization, you can ask questions today, but a lot of times that is a technical assistance call where we really help you figure out who are you as an organization, what are you dealing with, and help you figure out the questions that you need to be asking to solve it for yourself. And I'm going to make sure that you have my email address, and we are available at Confidentiality Institute to do technical assistance. We get funding from the Office of Violence Against Women through National Network to End Domestic Violence to support you. And so we're always here as technical assistance questions come up. The other thing that's important under VAWA, VOCA, and FIPSA, just like under HIPAA, is that a statute or a court order can require sharing. It has to be a valid court order, and that means an order that a court is actually allowed to issue. And I can just tell you as a practicing attorney, there are unfortunately way more orders that judges issue that they're not allowed to issue than any of us would like. But there are ways to challenge those. Or a statute, a legislature might make a decision. And again, mandatory reporting of child abuse where it applies is the most classic example of a legislature saying, we want to have a rule that says it's not the professional's decision, it's not the violence survivor's decision, we have just decided this is going to get reported. And I probably should have put an additional bullet on the screen that says, of course, that patients can always request sharing. I think the reason I didn't do it is because the very first bullet under VAWA VOCA FIPSA is that the violence survivor is always the one making the choice, directing the sharing. So who do these rules apply to? This is a source of some confusion, and I want to give a quick explanation. But again, if you are not sure, if you're feeling unsure how things apply to you, then you can reach out for technical assistance. But HIPAA doesn't apply. HIPAA isn't a national privacy rule. It's the most famous privacy rule, but it doesn't apply to everybody. It applies to what is called in the law covered entity. And covered entity is folks who are providing healthcare and using electronic billing. And the reason that that's a big issue is that there are a fair amount of victim services providers who might have a therapist on staff, or they might have a forensic nurse on staff, but they're not billing, they're not charging anybody for the services, they're not using any kind of electronic system to send out bills or get paid. If that's true, if you're in an organization that's providing mental health services or clinical services or nursing services, and you are not billing anyone for it, there is a good chance that HIPAA does not apply to you. So just kind of think about that. I've heard some organizations say, well, we voluntarily follow HIPAA. That doesn't really work because HIPAA has its own enforcement system. And so if you say you voluntarily follow HIPAA, what you're telling survivors, you're implying that they get access to that enforcement system, and they don't. So just being really clear about that. The other set of people that HIPAA applies to is business associates of covered entities. So that's organizations that have signed an agreement to say, we agree to follow the HIPAA rules because we are receiving healthcare information and we are working with you. And once folks do that, then they are covered by HIPAA and they can have it enforced against them. And they have to follow the HIPAA rules about security and technology, which can be strict. And so it's very important that if folks are considering entering into that relationship, that they're actually prepared to follow those rules. So interestingly, though, in a lot of ways, I think that the VAWA VOCA FIPSA rule is stricter. It's certainly more protective of survivor choice than the HIPAA rule is. And so one of the things about signing a business associate agreement is that it might actually require you to do more sharing of information than you're allowed to do under the VAWA VOCA FIPSA rule. So this can be a little bit complicated, and I don't want to confuse you or get too deep in the weeds. I'm just trying to raise kind of high level questions that I've seen come up, so that if you're seeing those questions in your organization or in your partnerships, you know to see the questions. You can issue spot them, is what we say in the legal business. You can issue spot those questions, and then you can reach out for technical assistance to help sort them out. So who does the VAWA VOCA FIPSA rule apply to? It applies to organizations that get the funding. So if you are a VAWA grantee, a VOCA victim assistance grantee, or a FIPSA grantee, and sometimes it's a little bit tricky to know because sometimes that money goes first to a state agency and then gets forwarded to your organization. That's something for executive directors, development directors, leaders in the organization to be clear on, so that you can follow the rules. But it doesn't necessarily apply to your local police station, right? So sometimes what I hear people get confused about is they think, well, all violence survivors are entitled to VAWA level privacy every time they talk to anyone, and that's not the case. It is that when they come in and talk to a federally funded victim services program, that strict rule is one that has to be followed. Now, many states have also passed their own strict rules about confidentiality and privilege for victim services programs. But it's different in different states. They all look different, and some have them and some don't. So for example, Colorado has a very strong privilege statute that says that a victim advocate shall not be examined either by testimony or through records without the victim's consent. So what that really means is that the victim gets to decide whether or not their advocate will testify in court. And the advocate cannot be forced. And that's a very, one of the stronger statutes in the country. It doesn't really have any exceptions. And there is a Supreme Court decision in Colorado that says, yes, we really meant it and we're protecting this. So on the other opposite end of the spectrum, in Kansas, there is no statute that says that a victim advocate is privileged to refuse to testify in court, or that a victim is privileged to refuse to allow their advocate to testify. In Kansas, pretty much all the programs providing services are receiving federal funding, so they are following that strict confidentiality rule. We don't volunteer information. We let survivors make their own choices unless we're forced to share by a court or by a legislature. But in Kansas, a court does ultimately have the power to force that sharing. So that's just an example of the differences. In the materials, when we talk about resources here today, I'll let you know where there is a chart that tries to keep track of each state and what their current privilege statute is, so that you can look up yours if you're not sure. That statutory chart includes all the United States and the US territories. It does not include tribal courts, tribal government, tribal codes. And we're working on it. But I will say I have not yet encountered a tribal code that has in it a privilege statute for advocates. But if anybody knows of one, please send it to me, because I'm always trying to develop my knowledge, and I need a network of helpers to do it. Okay, we're going to talk about how do we collaborate across different professions, given kind of all these things about confidentiality that we've talked about. But before we move to collaboration, are there any questions that folks want to ask about privacy, confidentiality, and privilege, about HIPAA, or about VAWA VOCA FIPSA? All right, it's possible someone's typing and I haven't seen the question come up yet. I'm going to start to move forward, but if a question comes in, I'm going to take a pause and make sure to answer it. So when we think about confidentiality and collaboration, I want to start by asking you to think, and this is something you're going to do for yourself. I'm not going to make you share it. But I'm going to ask you to just take a moment and, either using pen and paper or an electronic device, whatever you like best, how do you collaborate now in your professional work, especially thinking about how do you serve violence survivors? Start by sort of identifying yourself. What kind of professional role am I in? And how am I collaborating with other professionals? And how do I make decisions about what to share with those other professionals about the survivors I work with, whether I call them survivors or patients or clients? And so that, in order for me to let you do that thinking and writing, it means I have to stop talking, which you might have guessed is a hard thing for me to do. But I am going to be quiet and give you a couple of minutes to think about, how do you collaborate now? What's your role when you're doing it? And how do you make those decisions about what to share? Okay, I'll give you another half a minute. Okay. So no one is required to, but does anyone want to share with the group how you answered those questions? So the tricky part for you all is this is a small enough group, and I have an attendee list. I'm trying really hard not to be my law school professors because they were a particular breed of people. But I really want to hear your thoughts. Simone, Laura, either one of you be willing to share? Or Rita, Celeste? So Simone says that when you think about making that decision how to share, that you work on being survivor-led, asking what survivors, what they feel comfortable with being shared. Right, and I think that's really important. Sometimes I see victim service providers when they're, and I am not sure what role you're in, Simone, but I'm guessing you're in a victim services provider position based on the survivor-led focus. But sometimes I see victim service providers when I say, what do you share in a collaboration? I hear them saying, nothing. When I say, what would you share with a multidisciplinary team? Or what would you share with a sexual assault response team? And I will hear them say, nothing, I share nothing. And I understand why they're saying that, right? Because they took in an idea that confidentiality is keeping secrets and refusing to share. But it's incredibly important to lead the way that Simone is leading, to be like, what my decisions about what to share are not my decisions. They are the person who talked to me. They're the person who trusted me with their information. And I'm going to come to them and say, I am participating in this collaboration. This thing exists. Here's who's on it. Here's what I know about the group. Here's thoughts I have about how the group might help you. And you get to have your own thoughts about how the group might help you or not help you. You get to ask me questions about the group. And do you want me to share anything? Do you want them to know anything? What would you want them to know about you, about what you're experiencing? What questions do you have for them? Do you want me to help put you in contact with a person on the group, with the whole group? Or do you want me to carry a question to the group for you? When you're leading from a survivor-led place, then that's that focus of, I am communicating with you about what's happening and where I'm out in the world, where you might be discussed. Like, I don't have control over whether this group discusses you, but I can be in the room and you get to direct me, even if you might not get to direct other people in that group. You get to direct me about what I do or don't say. Right? That's that role of lifting up someone's voice. You know what would actually be really helpful for me is, could everyone weigh in on the chat right now? What brings you to this webinar today? What kind of professional role are you in? What's your job title? Or if you're volunteering, what kind of work are you doing? Everyone could tell me that. It would just help me know the variety of folks that are with with us today. Thanks, Simone. Terrific, thank you. So Vista, at a nonprofit that works on food insecurity. Well, of course, we know, right, that economic instability and food insecurity and housing instability are often closely connected to experiences of trauma and violence. So absolutely connected to what we do, right? And thanks, Laura, for letting me know that you're a development director, right? That's an important position to think about. How do we think about information sharing? What are the missions and the mission and values of your organization? And then also, what are the pressures, right? The way in which individual stories and sharing those stories help organizations to bring in funding and raise money and really kind of balance those things. That's nuanced for sure. And then, of course, doing prevention education. And again, I have several of you appearing as Simone, I assume that you actually have different names, but you know that doing prevention work is closely connected to, but a little bit different from being a confidential advocate. And prevention work can be really tricky because when you go out and you do your prevention work well and you do presentations, people may then be coming to you to make disclosures because they feel like you're going to understand and they can trust you, and this is a place they can seek services. And that can be sort of tricky, really thinking about what is your role and what kind of promises are you able to make around information? Are you able to offer confidentiality? Do you have privilege? We can all be respecting other people's privacy all the time by trying to alert them what our rules are before they start talking with us. And I'm always here for technical assistance for prevention educators because that can be tricky. Okay, great. This is the kind of work that I would like to see every collaboration doing, taking some time to think about in the collaborative group, why am I here in the group? What is my role here? What do I think I'm bringing to the group, both expertise and information, as well as individual patient, client, survivor information? Who gets to make those choices? Is it me? Is it the person who's experienced the trauma? Is it my boss? Is it the court? Like, you know, how is that being made in any collaboration, whether it is an informal collaboration, like I need you to get things done, or a formal collaboration where you're actually meeting in a fatality review team or a sexual assault response team. All of those should be doing some foundational work to understand. I think it's a really good idea if there are organizations that are going to be working together regularly. For instance, the group that, a group that does advocacy and organizing for the Indigenous community, that knows that people may be coming to you who have experienced violence and are going to want to connect specifically with a confidential advocate. If we know that's going to happen between our organizations, thinking in advance, how are we going to work together in a way that respects where each of us is coming from and understands? MOUs, memoranda of understanding, are something that I think get used, but they often get used without a lot of thought. And especially the development director on this may know exactly what I'm talking about, that like the grant will say, well, you must have an MOU. Somebody uses a copy of an MOU that was written a decade ago. You change the names and you sign it because the grant is due and you get it out the door and no one remembers what it said, right? I have signed those myself. I want to make an argument that MOUs are a way of their agreements and understanding about how we're going to work together. How are we going to understand each other well? And so I like the idea of using them to set boundaries and educate partners. And it doesn't always have to be a formal written MOU. So here's an example. When I was in a legal aid office, we represented a lot of domestic violence survivors in complicated divorce and custody cases. And there was another nonprofit law firm in town that only represented domestic violence survivors in complicated cases. So we didn't necessarily have permission to tell each other about the clients that we were serving. We didn't have permission to share identifying information. But there were times when my office would realize that we had a conflict that meant as a lawyer, we were not allowed to represent this client anymore. We had to stop or not take the case on. And that's a very stressful thing when you're a nonprofit lawyer, because it's not like your client can just go use their money to hire another lawyer. You're free and you're worried that no one's going to help them, and it's not their fault that you have a conflict. This other nonprofit law firm in town would have a similar issue come up for them. And in both cases, we wanted to be able to call a client and say, I have bad news. We have a conflict. It's not something I can fix. It's not your fault, but I can't be your lawyer anymore. But we also wanted to be able to say, and there is another fantastic group of lawyers that can be your lawyer. So the agreement that we worked out, and it wasn't written down, we didn't sign it, but it was an understanding with each other that we developed by discussing. The agreement we reached out was that we trusted each other, and that if you call me and say, I cannot tell you the name and I cannot tell you the details, but I can tell you that there is a divorce and there's domestic violence and there's a custody issue and we have a conflict, so we cannot represent the client. If you don't have a conflict, will you represent the client? And we made an agreement that we would say yes to each other. So we didn't have to share any private information about our clients to do that. What we did is we developed our relationship and said we trust each other, that we wouldn't do anything that would be bad or would be unfair or underhanded. And it made it better. I mean, it just made it better because it created a space where I could call a client and say, this is bad news. It makes me sad that I can't be your lawyer anymore. And I know I can hand you off. We talk about warm handoffs all the time. This is a form of a warm handoff to another group of really good lawyers who are also free, who they will have to do a conflict check, but assuming that there's no problem there, they can take over and be your lawyers. And it was reciprocal. Now that's a very specific example, right? But it is an example of professionals discussing with each other where they're coming from, what their needs were, and finding solutions that were about trusting each other and understanding each other, not about, I need to send you this individual client's file and so you know everything about them before you even tell anybody whether you're going to help them or not. Okay, so think about MOUs as that. But one very important point I want to make about MOUs, and this is a source of some confusion, is that a lot of groups will have an MOU that says when you join this group, everything that gets discussed in this group stays in this group. And that might be an appropriate thing for your group, but that does not change your legal duties when you walked into the group. So when you're thinking about participating in a collaboration, there are really two different questions. The question is, what do you have permission to tell the group? And then once the group knows information, what do they have permission to do with it? So if you are a confidential advocate, you could sign 100 MOUs. You still do not have permission to decide what gets shared in the MOU. It's still, that decision still belongs to the survivor. If you are a healthcare professional, if that collaboration is specifically about providing healthcare, then you, the healthcare professional, are allowed to decide what gets shared in that room. But if the purpose of that group is to increase prosecution, then you're not allowed to decide, and the patient gets to decide what gets shared. So I'm just kind of throwing that out there because I see a lot of people who say, well, I signed an MOU, so I think that means I tell everything I know in the group. And nothing about an MOU changes your legal responsibilities about whether you have permission to share with the group. But an MOU can set the rules for what the group does with the information it gets. So I do see that it's somewhat common that there's a rule that says for a multidisciplinary team or a SART or a domestic violence high-risk team, that it will say that what happens in this group stays in this group. That's an important thing to have deep conversations about, because is that actually what you want? So a fatality review team almost always has that rule, and that's very important to the fatality review team because professionals are making themselves vulnerable about a very difficult situation where someone was killed. And they want to be able to speak freely and not worry that it's going to get shared elsewhere, right? That makes a lot of sense for a fatality review team. But if there's a domestic violence high-risk team that is discussing an individual survivor and an individual prosecution of their abuser, and there are things happening in that meeting that survivors want to know about, need to know about, that would help them stay safe, right? And to navigate their systems and moving forward, it might be a terrible idea to have a rule that says that nothing can be shared with that survivor. And it might be an impossible rule because prosecutors have a duty to share things, certain things with the defense attorneys. So again, this is high level. But whenever groups come together and they make rules, they want to pay really close attention to whether the rules make sense for what they're doing. And if you are especially if you are a survivor advocate, really thinking about how do these rules work for survivors or against their interest, and how can I advocate that the group have rules that work for survivors? And so that's true anytime you're thinking about doing a collaboration. You really want to think about who is this collaboration serving, who is this for, whose situation is being improved. All of these things on this list are things that I have heard folks identify as who a collaboration is for. So is it to serve the needs of an adult who's survived violence or of a child who's been abused or neglected? Is it for a family unit that has experienced trauma and the collaboration is trying to help the whole unit, which is a different thing, right, from just trying to prevent abuse and neglect of an individual child? Is the purpose of this collaboration to improve the community or the well-being of a broader group of people? There are a lot of collaborations that are happening because a funder said, I will give you money to make this collaboration happen. I would say that's not ideal. It might be that you have a collaboration for two purposes. One is because a funder wants to pay for it, and then you're like, okay, but what are we going to achieve by doing it? But it's important that folks take the time to figure that out and think about it. There are a lot of collaborations. I have seen this quite a bit where there are collaborations that are the result of a legislature, a state or federal or a city council even, saying, we want to take action. There's a problem and we want to address it. And so we're going to have a blue ribbon group of people meet. Again, that's another example of where I think it's very important for that blue ribbon group of people to say, thank you very much for appointing me. Now we need to figure out what are we actually trying to achieve and who are we serving? Because that question of who are you serving will give you a lot of information about what information it makes sense to share with the group, what information you're legally allowed to share with the group, and how that group is going to use information. And when we think about these collaborations where different professions are coming together in one space, I think I pulled this quote out of the California Sexual Assault Response Team Manual, and I think it's a very important thing to remember that is not remembered often enough, which is that they use the word departments, but different professionals on a team can have different objectives, but a shared vision, right? So it can be that one professional on the team would like to see conviction because that is how they bring community safety and accountability into the world. That there's another professional on the team that would like to see the survivors wishes and needs met, and that another person on the team would like to see, there not be any harm in the future. So there's actually different objectives, but you can have a shared vision that we're trying to create a world where people do not experience trauma and violence, but if they do experience it, they have an ability to recover, and that we don't create new trauma and violence in our effort to address past trauma and violence, right? That's where restorative justice ideas come from. So a group can have a shared vision of the world that you're trying to build, but you might, as professionals, have different objectives where you want to get to in your work. Seeing that, recognizing that, respecting that is incredibly important to building collaborations that work, and not judging each other for not doing things in the exact same way as across the board. All right. Questions before we move into talking about person-centered approaches to releases? Does anybody have any questions or thoughts about what I've talked about around collaboration? Okay. So if you are in a position where it is the survivors that's making the decision about what information to share, not you, the professional, or your organization, then survivors are going to do that by giving you a release. Now, I'm going to talk in this section about sort of the VAWA idea of written informed releases. Some professions, you do need to get permission instructions from your client to share information, but it doesn't always have to be written. This section is really going to focus in on what's that federal rule for victim services providers. The HIPAA rule is sometimes it needs to be written, sometimes it can be verbal, sometimes it's just if the patient doesn't object while it's happening. So that question of releases under HIPAA is a little bit more complicated. And so we're not going to go into that right now, but if somebody would like help about that, I'm available to give technical assistance. So when we think about releases, we really want to think about what purpose they serve. And again, this is similar to that collaboration question that I asked before, which is, who are these things for? And so we're going to ask this question about the releases. If you're dealing with releases in your work now, I'm going to ask you to weigh in on a poll. So in your work now, which of these goals are your releases meeting most of the time? So when you use releases with clients, with survivors, with patients, check all that apply. If you think that it's meeting these goals. And since I know we have a range of professions, if you're in work where releases just don't come up for you, you're not dealing with them, if you can just say that in the chat, and then I'll know not to wait for you to answer the poll. I'll give you another minute to think about it, because I know there's more than one, and I asked you to think about all of them. Okay, going once, going twice. I'm gonna end the poll. If you have any last thoughts, put them in. Okay. Okay, so we're showing you how folks answered. And I know we don't have a huge sample size, But it's interesting, right? When you start to reflect on if you are dealing with releases, what kind of role are they serving? I would love to see 100% of them say that the person who's signed in is expressing their wishes about what they want, right? And I would love to see 100% say that the person who's signing it understands what it means. Who will see what? And I think it's really hard on you in doing your work if you're not certain what the person who's signing it wants. But I know that there are a lot of release forms out there that kind of get, I call it the tyranny of the form, right? And there's a form that exists and it's been passed on. And maybe when you first started your job, someone handed it to you and said, this is the form we use. And so you use it. But if someone asked you, what does it say? What does it mean? You might not be entirely clear, right? And so this is very common. I actually once had an experience where I tried to go see my doctor, and she had moved and joined a new group, and they gave me a form to sign. And there was a part of it that I wasn't, and I'm a lawyer, and it wasn't clear what it meant. So I actually crossed that part off and just wrote a new phrase that was clear, and I thought was maybe what they meant, but it was definitely clear to me and what I was willing to agree to. And the front desk told me I wasn't allowed to make any changes. They couldn't explain what it said to me. There was no one who could talk to me who could explain what it said, and I wasn't allowed to see my doctor until I signed it. It was a very frustrating, upsetting experience. I have not been back to that doctor since. That's on me. But, you know, every time I think about going back to the doctor, there's a level on which it doesn't feel safe. I never saw her that day because I wasn't going to sign a form I didn't understand, and no one could explain it to me. So that's a pretty extreme example of how bad it can be. But I think part of the reason that happened to me is because I was the first person who ever asked a question. I was the first person who ever thought I was allowed to ask a question. And I was the first person who ever looked at this and thought, I didn't think it was my fault that I didn't understand it. I thought it was badly written. And I was willing to challenge it. So a whole lot of people were signing forms that I don't think they had any idea. Nobody in the room knew what they said or what they meant. That is not the ideal. I think that's obvious, but that is not the goal of releases. So under the federal confidentiality standards for victim services providers, the rules around releases are pretty strict and pretty detailed. They have to be written. There's no exception for an oral release of information. So if you are not in victim services, but you're talking to someone who's in victim services and you're saying to them, come on, can't you just call your client, the survivor, and get permission to share this with me? Just calling is not going to do the trick. Don't ask people for that because the rule says that it has to be written. And we talk about the reason you see that mnemonic waits on the side of the screen is because we talk about a good advocate waits for a survivor to give instructions. And those instructions are written. They are approved by the survivor. So truly approved, either through a signature or some kind of a formal mark. And the reason we talk about a formal mark is because it is possible to use technology. It is possible to use digital systems, to use email, to use the like DocuSign and Adobe Sign and things like that for a survivor to give instructions. And you just want some way of knowing that they approved it. And that approval has to be informed. It has to be they understood what they were signing and what were the pros and cons, and you cannot make it a condition of service. So you can't either say or imply, the only way I'm going to help you is if you agree to release your information. They have to be time limited, and that time limit, it just means there has to be an expiration date, and it should be based on what the survivor wants. What is the problem that that survivor is looking to solve, and how much time is needed for you to share information to meet their need, to solve their goals. So really focusing on what are their goals, what do they want, and what amount of time is necessary to do that. And it should be specific so that they understand what they're asking you to do and you understand what is being asked of you. It's like a two-way piece of communication. So there are some, I have some slides here that go into this in more detail, but it's incredibly important to pay attention that releases are serving survivor goals, not organization goals, not funder goals, not collaboration goals, but survivor goals. Now, it is possible for a survivor to say, I want to speak at your fundraiser. I want to write a testimonial for your grant application. I want to have my story shared as part of your grant application, but I want to know what you say about me first, right? Or I want your newsletter. Yes, I am. Thank you so much for your help, and I feel so good about it. And I would love, if you think putting it in your newsletter helps you, then please do it. But you want to make sure that person knows what's being written about them and they have approval over it, right? So it is possible for people to say, I want to participate in growing your organization, in growing this community, and growing this movement, and making sure other people can get this kind of help. But it can be very tricky to figure out when or how to have that conversation so they don't feel forced. But it's just incredibly important. And I've had conversations with collaborative groups, and they have said, what do you think of this release form? And I say it's, and all I say to them is, what is the survivor goal that is being met through this release form? And literally the answer I have gotten is, well, this makes it possible for us to do better reporting to our funders, and it makes it possible for us to get more funding. And I think you can hear in my answer that there was nothing in there about what is a survivor goal being met. So really paying attention to that. The pressures to fund work and the pressures to please collaborative partners, government entities, funders, those are intense, very real pressures. And we have to pay very close attention to what we're doing to make sure that we're putting survivors first. And of course, those signatures have to be voluntary and freely given, right? And knowing that when you're working with trauma survivors, these are people who have been told they don't have choice, or that on paper they're allowed to exercise choice, but not really. And especially if you are in the United States and you are Native, this is a country that plays a lot of games, right? A long history of playing games, of saying, you know, this is a partnership, this is a choice, this is a settlement or a negotiation. And it was really all baloney. So people have every right to be nervous, worried, or suspicious about whether or not they truly have choice. And so everybody serving that community has to go above and beyond to ensure that people understand that this is not a requirement. This is not a condition of services. You will not be punished. You get to wait and see and decide what's right for you, decide whether you trust me. It's like literally giving people permission to say, I don't trust you yet. You haven't earned it yet. There's nothing wrong with that. We talked about that reasonable time limit. Releases can absolutely be renewed. If it turns out that you weren't able to get something done within the time limit and the survivor's like, I want you to have more time, then they can renew it. I think the thing that in some ways, and this is lawyers' fault, I'll take my community has to take responsibility for this, that we pay more attention to what does the form say, and how would a judge reading the form later, if there was ever a disagreement, that's what we pay attention to. And what we should be paying attention to is the conversation. How do we have a discussion? How do we have a discussion that's real? And so I would like you to think about a time in your own life, and I am not going to make anybody talk about this time in your own life, but if anybody is up for it, I would love to have you share the reasons why you signed. But using your own piece of paper or your device, think about a time that you signed an agreement or consent and you knew that your decision was not informed. In other words, you didn't really necessarily understand all the ramifications of what you were signing, but you signed it anyways. You made a decision to sign it. Write down 3 reasons why you signed anyways. What were the reasons, pressures, decisions that you made about why signing it was the right thing to do? Okay. So if anybody's willing to share in the chat with the group, again, you do not have to share the details of what you were signing, but what were the reasons that you were able to identify for why you just signed? And I can share some of the reasons why versions of just signing. I'm getting a rental car and I just want to get out of there. I know that if I read the agreement, there might be something in it I don't like, and I just want my rental car because I'm tired and I want to leave. Sometimes when I am in the store, I don't know if you've noticed, but if you buy something now at a store, you will always get asked for your phone number or your email. And most of the time I say, no, thank you. I don't need to share that. But sometimes I just don't want to be socially difficult. I want to be the person who's agreeable and gets along with people. And it feels socially difficult to say no. So I just say yes, which is a version of signing and consenting, even though I don't really know what they're going to do with it. I mean, I have suspicions based on my work as a privacy expert, but I haven't figured it out or checked, right? So this issue of you don't want to be socially difficult is probably the number one reason why people sign things. And the second reason is because they're afraid that they're going to be told they can't have the help they need. When people are coming in for free help, it's incredibly important to remember that they are not, it can be taken away very easily. And so they want to be that agreeable, easy to work with person who gets the help that they need and doesn't have it taken away. Oh, great. Yes, thank you, Angel. Signed it for a job and you needed the job. And you figured if something went wrong, the corporation would win anyways. I totally get it. I totally get it. I co-signed, I told you I have a son who went away to college and I co-signed his lease. That was an informed decision because I read the whole lease. There were parts of the lease that I thought were terrible, but I signed it because my son was really excited about the apartment and then didn't want to get in his way. Right? So there are all kinds of pressures that can cause us to sign things. The goal, if you're doing survivor-centered victim services work with people who have been traumatized and had choice taken away, is to you do the work. You do the work of eliminating those pressures. You do the work of clearing all that debris away from them so that they can just make a real choice. And so sometimes that means explicitly saying, I give you permission to not sign. I'm just going to put this form over here and you're going to decide. You can take it home and think about it. You can decide what's best for you. One thing I used to say to my clients is, I'm on salary. I get paid no matter what you do. It's okay for me. I will help you in a different way. If you want me to share this information, here's how I could use it to help you. And if you don't want me to share it, I'll help you in a different way. But saying that out loud is a kind of ensuring that people know they have permission and that I don't think it's socially difficult if they don't sign. Certainly, it's the opposite of the experience that is kind of the general American approach, which is just sign this form so that we can move forward. Really thinking about how are you actively creating choice for people. You get to wait and see. This release is your instructions to me. This is not what I want. This is what you deciding what you want me to do. But the other incredibly important option is people can share for themselves. Is there a place for people to share for themselves, to be in charge of their own statements? Are they saying, I would share for myself, but that person won't talk to me. They won't take my calls, or I don't know their phone number. I can't get through. And you're like, ooh, I can get through. I'm on a team with them and I have their direct phone number. I can get through. You want me to set up a phone call? And then I'll be there if you want me there. And you can talk and I'll make sure they listen to you. That's the role that I can play. So I don't have to be your voice. I can make sure your voice gets heard. Really thinking about what are all the different possibilities instead of just thinking, oh, you know what, my job as an advocate is to replace the victim's voice in conversations. Your job as an advocate is to lift up the victim's voice. And sometimes that means speaking on behalf of the victim because they're saying, I don't want to be the one who has to do this. I want you to do it for me, but I'm giving you really clear instructions. When the time is right to bring up actually doing the paper form, you want to make sure you're using a good form that everyone understands. So we have put together, Confidentiality Institute and the National Network to End Domestic Violence have put together a template VAWA release form and also instructions for how to use it. And those instructions are just like, I wrote them, so they're just like the messages that I'm giving you here. And you can find that at this link. And again, we're gonna make sure you have the handout for today, and it will have this link in it, but also the address. So you can go and look that up. And I hope that you find it useful. If there's anything about it that could be better, let me know, because we're always trying to improve. And this form is the result of us realizing that the old form was too lawyerly and not enough about real people communicating with each other. As I said, it is possible, I think, under VAWA FIPSA-BOCA to use technology to obtain consent as long as it meets all the standards. This is really the victim's instructions. They understand what's happening. You confirmed that the victim is not being impersonated, and it's clear instructions that have an expiration date. But just always leading from this space that confidentiality is about respecting people's choices. Right, I promised that I would let you know where you could get, where you could get more technical assistance. I'm on this confidentiality technical assistance project with the National Network to End Domestic Violence, the Safety Net project. So you can email safetynet@nnedv.org with questions, and you can email me, Alicia, at confidentialityinstitute.org with questions. And you can email both of us at the same time, and then we'll figure out which of the, there's probably about 8 folks on the team, which of the 8 people on the team is kind of the right person to get back to you the quickest. But you can also go to techsafety.org/resources. There's a huge number of resources there for VAWA grantees about confidentiality, collaboration, privacy, best practices. And again, if there's not something there that you wish was there, tell us, because we're always trying to improve it. And then I'm also giving you my website, confidentialityinstitute.org. We have about a minute left if anyone has a question that they want to ask, and I'm always willing to stay on for a few minutes past our assigned time to take questions, but I like to finish the presentation on time so that folks who need to go can go. Does anyone have a question they want to ask? Okay, I have either answered every question you've ever had, or you're still processing what we talked about. And if you've got more later, or if someone else who wasn't here today has a question, please reach out. We're here to assist you. What you do is important. It's complicated, it's nuanced, and we should always be supporting each other and growing. And that's why I'm here, and that's why Redwind is here. And thank you so very much for bringing me in today. And I hope everyone has a really wonderful afternoon.
Thank you, Alicia. Before we end the session, I want to let you all know that there will be an eval popping up once Zoom closes. We'd love to hear what you thought, so if you're able to fill that out, we'd very much appreciate it. Coming up next in the series is responses for our Two-Spirit/LGBTQ relatives on July 28th, and that is at 1 p.m. Mountain Time. Again, that's July 28th at 1 p.m. Mountain Time. If you have any questions, comments, or are seeking TA, Hope Key is the Redwind project coordinator for the Responding to Urban Natives grant program, and she is available to provide technical assistance. You can reach her at hope@red-wind.net. I will be putting that really quickly into the chat. In closing, I'd like to thank our presenter, Alicia. I'd like to thank our captioner, and I'd like to thank all of you for joining us. I hope you all have a wonderful rest of your day. I hope you all stay safe, and I hope to see you all at the next webinar.